Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton has shared some new thoughts, brand new thoughts, this out just yesterday on just why he thinks, first of all, a few things, why the SEC's actions are completely nonsensical and why John does believe that Ripple's going to win this whole thing. You know, the claims of the SEC against Ripple selling investment contracts, unregistered securities, it just doesn't stand to reason. And I would say that John rather artfully pointed this out in an awesome thread that I think you're all going to enjoy. So I just wanted to share this with you, and I'll share with you some of my thoughts along the way. But I encourage all of you, if you've not yet followed John on Twitter, you can. He is at John, John, and then his middle initial, the letter E, and then his last name, Deaton, which is Deaton, and then the number 1. So there you go, at John E. Deaton 1. I like to give credit to people that put good stuff out in the community and prop those up that are helping the XRP community. And Mr. Deaton unquestionably has been helping all sorts of people sort out what's going on here, because most of us don't have any sort of legal background, and it makes it difficult to determine what makes sense in terms of buying, selling, holding XRP. To what degree is the situation more risky? It's hard to make sense of it if you don't have a legal background. So to John and every lawyer out there that's been helping the XRP community along the way, I appreciate it, and I will continue to prop up all of them, and I encourage you to support them as well if you're an XRP community member. And so his thread here begins as follows: Ripple's due process claim. In Ripple's answer, it asserted a defense that the SEC should be barred from claiming XRP as a security today because it violates due process and principles of fair notice. Previously, I discussed a similar concept called the doctrine of equitable estoppel. I explained the law protects a party from being harmed by another party's voluntary conduct. That conduct may be actions, inaction, silence, or acquiescence. Although the SEC never declared XRP a non-security, for 8 years it openly traded in unison with ETH and Bitcoin. During this time, some of the SEC, including Clayton, who, by the way, this is me speaking now, Moon Lambeau, Clayton is an asshat, and now back to John Deaton, including Clayton, commented that Bitcoin and or ETH were not securities. For 8 years, the SEC's actions, inaction, silence, and acquiescence implied that XRP was also not a security. Let's review a few of the SEC's actions, inaction, silence, and or acquiescence related to XRP. And this is where it gets really fun. During the period of time the SEC claims XRP was a security, the SEC granted Ripple permission to take a minority stake in MGI. That would be MoneyGram. You guys do realize that. I've talked about it on the channel. I'm not sure how many people have heard, because I know not everybody listens to every video I put out there. But you should, and I'm offended that you don't. But yeah, the SEC actually approved this, and so you got to sit here thinking, okay, if they're studying what's happening with Ripple at XRP, and along the way they've been thinking XRP is actually a security, why the hell would they ever approve such an action? It makes no logical sense whatsoever. And so John Deaton continues. Ripple invested $50 million purchasing approximately 9% of MoneyGram. The SEC approved this purchase of MoneyGram with the full knowledge that Ripple would encourage MoneyGram to use XRP as a cross-border utility token related to remittances. The SEC allowed the use of this so-called illegal security to be utilized not just by Ripple, but by MoneyGram. The SEC admitted to this knowledge when it stated in the complaint that Ripple paid money transmitter significant financial compensation, often paid in XRP. The SEC was fully aware that MoneyGram would not hodl XRP. The SEC knew that MoneyGram would sell XRP in the secondary markets to investors, such as all of us XRP holders. Thus, it appears the SEC, believing XRP to be an unregistered security, provided consent for XRP to be purchased and or utilized by MoneyGram and then sold in the secondary markets to innocent investors with no connection to Ripple or even MoneyGram, because purchasers of XRP on exchanges do not know the identity of the seller. If the SEC truly believed XRP to be an illegal security, why would it allow this transaction to take place? The answer is because the SEC knows very well that today's XRP is not a security. And by the way, I've been talking about that too. If I could just pause here to take a moment. Look, I understand the claim of XRP being a security is out there, but it just goes back to this whole idea of, the SEC not requesting that a judge declare XRP to be a security in the whole complaint. And a judge can't declare something that isn't requested. So you got to sit there and think, to what degree does the SEC even believe what they're claiming? I don't know exactly. It seems to me like it's just an overcharging situation, and they want, it's a money grab perhaps. They want to fine Ripple, and maybe that is ultimately going to be all that it is. But I just, it seems crystal clear to me that the SEC is not confident in their position of XRP being a security today, but Ripple is very confident in their position that XRP is not a security today, as evidenced by the fact that they are pretty well demanding that the court actually, the judge, end up declaring whether or not XRP is a security. And so again, SEC did not request that declaratory judgment, but Ripple is, and as a result, it's going to happen if this thing goes to trial. So and again, they still could settle, but it's just interesting to just recognize this. Anyway, so let's continue with John's comments now. XRP has been trading in the secondary markets since 2013. In 2015, the DOJ and FinCEN settled a case with Ripple and determined XRP was a virtual currency, and that Ripple is a money transmitter of XRP. The settlement required Ripple's XRP transactions comply with laws that do not apply to security transactions. This is an agency of the U.S. government classifying XRP as a virtual currency. Also in 2015, the U.S. government entered into a consent agreement related to the sale of XRP to Roger Ver. The U.S. government settled with Ripple, and the SEC didn't allege securities violations, nor did the SEC issue a cease and desist letter or seek an injunction to stop sales of XRP. These government interactions and inactions with Ripple involving XRP implies that XRP is not considered a security. In 2017, the SEC brought high-profile ICO cases against several companies, alleging that the digital token that was being offered constituted an unregistered security. Two of these cases involved the EOS and KIN tokens. These companies raised capital by offering ICOs. These tokens were promised by the promoter who received money for that promise. This ICO scenario fits squarely in the four-factor Howey test of what constitutes a security. Because these ICOs constituted securities, the SEC shut it down. Ripple and XRP, however, were left alone by the SEC during these high-profile prosecutions. In fact, Brad Garlinghouse spoke out against these ICO token assets at the time. In 2017, XRP had been globally traded for over 4 years. The SEC, by leaving Ripple and XRP alone during the aggressive prosecution of ICOs, implicitly gave further confidence to investors and Ripple that the third largest crypto was safe from being called a security, just like Bitcoin and ETH. Japan, Singapore, the UK, Switzerland, and the UAE have declared XRP to not be a security, while the United States has remained silent. The SEC runs a node on the XRP ledger, along with thousands of other individuals and companies. And by the way, that's to me the most absurd thing. And I've said this on the channel before, but like, to me, I don't know what legally is the best argument, whether it is or isn't. I don't care. Just to me personally, the fact that the SEC has been helping, by running a node, helping facilitate these transactions on the XRP ledger that they declare to be unregistered securities, it's just the most laughable, absurd, unreal, bonkers sounding nonsense that I could have ever possibly conceived. Like, it's so out there. Really grinds my gears. Anyway, let's continue with Mr. Deaton's comments now. This conduct by the SEC implies that the SEC would not be conveying and or validating transactions worth billions of dollars in illegal securities. Yeah, yet they did. Even if Ripple ceased to operate as a company. The XRP ledger continues along with XRP, as the XRP ledger is open source and the SEC did not have to seek approval to run a validator node. Yeah, that's worth mentioning as well. Ripple did not give permission for the SEC to do that. Ripple has no special permissions. Well, how about that? Do you think that matters? Because I personally do. Let's continue. Since personnel from the SEC have made public statements that Bitcoin and ETH are not securities, and considering, like Bitcoin and ETH, XRP is a digital currency supported by a distributed ledger that uses cryptography to store and transfer assets, and since the SEC was silent, it was implied that XRP would be treated the same. The OCC issued a notice that banks could custody crypto. Clayton issued a letter that states the SEC agrees with the OCC in allowing banks to custody crypto. XRP was the third largest crypto. Clayton did not state that he agreed with the OCC, with the exception that banks can't custody XRP because they are unregistered securities. He never provided a statement that XRP or other cryptos could later be determined a security. Instead, it appeared that the SEC was in full agreement. He certainly didn't say, "We agree, but be aware that 8 months later, on my way out the door, I intend to declare the third largest crypto in the world to be an unregistered security." No mention of XRP whatsoever. It's 100% reasonable to assume that if the SEC agrees that U.S. banks can custody crypto, it would include the third largest crypto. The SEC, by this letter of agreement with the OCC, provided investors and Ripple confidence that XRP would not be classified as security, or the SEC would have excluded certain assets, or simply limited the custody to Bitcoin and ETH. The SEC was well aware that financial services companies such as iTrust Capital allowed U.S. residents and investors with absolutely no connection to Ripple transfer their traditional fiat IRA into crypto assets, including XRP. During the time period that the SEC claims XRP was an unregistered security, the SEC was well aware that a third-party entity, Flare Networks, unrelated to Ripple, announced, promoted, and then executed a digital asset token airdrop for all XRP holders. Flare informed the public that it would be airdropping at least one Spark token for every XRP token held by investors. If XRP is a security, and we only have a Flare because of XRP, what does that make the Spark token? If your XRP is a security, then your Spark must be a security. The SEC said or did nothing. All this SEC conduct, inaction, silence, and acquiescence is why the doctrine of equitable estoppel and the principles of fundamental fairness, fair notice, and due process should preclude and bar the SEC from claiming XRP as security. In short, in my opinion, Ripple wins. Bravo again, Mr. Deaton. You gotta love that. You can tell, like, even though it's just text, you can just tell that there's some fire behind all this, can't you? I sure as hell can. And it just makes all the sense in the world. So I just wanted to run through this and share some of my thoughts along the way. I'm going to continue to follow what all of these attorneys are willing to publicly share, and I'll be happy to prop them up and share their opinions on my platform, because I just want to share as much information on this topic as I can. It's important for us to get various opinions so that we can make our own decisions as XRP holders, because again, like, to me, just about the worst thing was, after this all happened, the not knowing bothered me the most, and just knowing that I couldn't go and research it myself, and I don't have a legal background. What am I going to do? So what I sought out to do instead is just find individuals, actual lawyers that could share their perspective. And the more I learned from all sorts of different lawyers, including Mr. Deaton here, the more confident I am that the SEC has made a damn big mistake here, and that, even if they technically, quote unquote, win a case against Ripple, it doesn't seem like a win will include barring Ripple from selling XRP, and it doesn't seem that it would include the legal determination that XRP is a security. And so then it's like this idea of like, okay, even if it's technically a win, is it really a win? Because to me, the answer would be no. The answer would be that the SEC lost. Even if not from a technical perspective, you get what I'm saying though, right? Because those are the things that matter most, right? So we'll see. There's no way to know for sure this is going to happen. I don't pretend to, but I'm feeling optimistic at the moment. Let's just say that. But I'll go ahead and wrap up there. Thanks for stopping by, my friends. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.